Guys, the topic for today, of course, is why is it important to learn technology laws if you are an IP lawyer? And before we go into the meat of the matter, so first we have to discuss some other things at the very outset. There are other things that are applicable, and we have to understand those to identify the context and the backdrop in which we are going to discuss today's topic. So first of all, what are the factors that have driven technological growth? That is the very first thing that we need to understand, because the same factors that drive growth in technology, those are the same factors that also drive growth in the domains of intellectual property. So what do you think are the factors that have driven technological growth? Can you name a few factors? These factors are all around us right now, and they are ubiquitous. It's not difficult to find out. Give me one factor each. Why has technology risen so significantly?
Anything would do. You can like make a guess.
Uh,
No.
there, there are obviously no wrong answers. Okay, no worries. We'll tell you. Okay, so the very first thing that we've seen is the accessibility, the growth of accessibility to the internet. So ever since Geo came into the picture with its zero pricing plan, and it triggered a tariff war between data companies and broadband companies. And since then, data has been extremely inexpensive in general. And the smartphones themselves are quite inexpensive right now. It is easier today to get a device and to get a data connection on that device. So the accessibility of the internet itself has grown exponentially, and that has been one of the reasons for growth in technology. Now, COVID itself is another huge factor that has suddenly pushed technology so far. And this is this is what usually happens in an emergency. Actually, whenever an emergency takes place, there are certain measures that have to be implemented to fix those emergent situations. And we find that these emergency fixtures actually turn out to stay there for a long time. And because of COVID, this kind of development has taken place. We've seen technological growth in a number of areas, and many business models have shifted online. They are growing more and more reliant on technology, and that is because of the push given by the coronavirus and the associated lockdowns. We also have a number of government initiatives to thank for this. We had demonetization back in 2016. India's fintech industry experienced a huge boom because of measures such as demonetization. And as a whole, the Indian government has been moving towards digitization of the economy. There are initiatives like Digital India and Atmanirbhar Bharat, and all of these are initiatives that are geared towards ensuring that the economy is moving towards a situation that is presence-less, paperless, and cashless. So that is what the objective of the movement is, of technological progress is. And of course, there are other factors that are solely technologically based, and those are not influenced by factors such as pandemics that we have no control over, or policy and governmental initiatives, but that are solely technological developments. For example, raw computational power, the the implementation of graphical processing units has led to a substantial increase in the computing power of computer systems. And this increase in computing power has again made other kinds of technology possible, such as machine learning models and artificial intelligence models. Those have been enabled by the presence and the increase in the raw computing power that any resource has. So these are a few of the factors that have really pushed forward technological progress, and these are reasons because of which technology is moving forward. So now that we know why or how, more accurately, how technology is moving forward, it also becomes pertinent to analyze what the relationship shared between technology and IP is.
Exactly.
Would you
Yeah.
like to see in here?
Yes. The subject matter of both intellectual property as well as technology is the same in the sense that they are both intangible properties. Intellectual property protects copyright, trademarks, and patents, which cannot be touched. They can only be perceived. Technology, on the other hand, also has similar subject matter. It has so for example, tech giants such as Facebook and Google, what they create is are mostly intangible properties, right? So the fact that the subject matter of both IP and technology is same make them go hand in hand. Other than that, there is also in the creation of IP, there is a whole lot of creativity and innovation involved, which is the case with technology as well.
Mm,
There is a huge amount of innovation involved in creation of technology, as well as there is creativity also. There are so many website developers, creators of website. There is so much of creativity involved. If you go through the internet, if you go through various websites, or if you go through various portals, you will see uh, things that can be intellectually protected. So this is something that is, that makes technology and technology as well as IP go hand in hand. They even have a symbiotic relationship with each other, in the sense that technology can be protected through intellectual property laws only. It cannot be protected through the traditional property laws. Intellectual property is what protects the technology. And technology has provided better means of protection of IP, in the sense that now IP can be registered online. All the registration processes of IP can now take place online. You don't need to actually go to the registry and then file these applications. It has become much more convenient. Making searches. So in order to protect your IP, you have to conduct some kind of due diligence first. You have to ensure that whatever you have created is actually original. That stands for copyright, for trademarks, for patents as well. So you have to ensure first that you are the first one to have created it. That can also be done very easily through technologies. For patents, prior art searches can be conducted online. There are various portals online available which help us to conduct these prior art searches. Similarly, availability searches for trademarks can also be conducted very very easily now through IP, the website of IP India, which would have been a very difficult task had this not been the case, had IP India not existed. So technology has had a very significant part in the betterment of the protection of intellectual property. Other than that, there is also technology, the technical processes. It has kind of forced intellectual property to enter into new dimensions. Tech
mm,
IP is entering into new areas of protection. So the traditional IP is, patents, trademarks, and copyrights. But what about, the newer technologies that are coming, such as, what about inventions which are made by artificial intelligence, or similar things which are, very newer ambits. We through technology we are seeing things which did not even, know could exist, right? So they will have to be protected, and intellectual property would be the way to go in order to protect them. So intellectual property, because of technology, is also entering into newer areas. So these are like some of the relationships between, technology and this is the relationship between intellectual property and technology, which kind of makes it handy to have, an information, a knowledge of both of these domains, so that one can protect IP in a better manner, and then technology can enable that from hap- that that intellectual property can technology can enable that, and then technology could be better protected through intellectual property as well. So this is why they enjoy a symbiotic relationship with each other.
And it it even goes as far to say that what is the very objective of intellectual property? When we start studying intellectual property, what do we learn about it? We learn that humans exercise innovation, humans exercise creativity, they produce works that have monetary benefits also. And in order to incentivize the continuation and creation of such works, intellectual property protection is awarded to them so that those monetary benefits can be protected. And thereby, technology and technological progress is incentivized by the domain of intellectual property. In that way, they are very interrelated, they are extremely interdependent, since protection of technology is the primary purpose of intellectual property regimes, and progress in technology itself leads to an renovation and an innovation of the regimes of intellectual property. So these both these regimes are actually pulling each other up continuously. So,
Hmm.
and a number of examples have already given by Abhishek. What we also see is that regimes of law that are particularly young in nature, that are still nascent, are largely harmonized internationally across the globe. So, if we look at intellectual property regimes, all of the domestic intellectual property regimes flow from the World Intellectual Property Organization, the GATT agreement, the TRIPS agreement, and various subject specific conventions and treaties that have been signed by nations. So, we see that the essential provisions of any intellectual property system across the world, those provisions are largely the same. And the same is true for technology law also. Developments that are happening place today, such as your OTT and streaming platforms, your blockchain and cryptocurrency mandates, initial coin offers, all of these are aspects that are developing today internationally, and the regimes that are regulating them are also quite connected and up to date with each other. Therefore, for anyone who wants to build an international practice, or for anyone who wishes to have some international clients to get remote work from foreign countries and have their earnings in dollars or pounds or whatever. So, learning intellectual property as well as technology law is a very potent tool for these people, because you can very easily find remote work in these domains. The growth of technology itself, the movement, the online movement itself has created significant challenges for the intellectual property domain. Now, why is that? Because we find that through the internet we can access anything with greater ease. We have huge amounts of information at our fingertips, and it is very easy to access materials, to copy materials, and to redistribute materials. So, all of that has been made possible by the growth of technology and the accessibility to it. So, because of these challenges, enforcement of IP itself becomes very difficult. And an IP lawyer cannot even hope to effectively enforce intellectual property protections unless he or she has a sound understanding of the medium of the technology over which any such infringement or any such violation is taking place. You have to have an idea about the medium, how it is accessed, what are the exact metrics in it, to be able to pinpoint liability at a particular location or at a particular offender. So just one of the examples that I would like to give in this regard is the issue of jurisdiction. The issue of jurisdiction itself has underwent such a lot of debate in context of online infringement and online online infringement of copyrights as well as trademarks. So, ever since 2006, the banyan tree judgment, even till last year when an extraterritorial injunction was granted by the High Court of Delhi. So the debate has been ongoing, and people are confused where to file complaints if a business is providing its services and products online. If I am sitting here in Delhi, and I have a business, but my registered office is in Delhi, and I am offering my goods for sale across the nation, across not just India, but even in international nations. So where will the locus be? Where will the jurisdiction arise? So there are such questions that need answering, and you as a lawyer will be able to effectively answer them for your clients and for any of your employers only and only when you have a sound understanding of how the internet actually works. What are servers? Where is data stored? So things such as this, some basics of technology law become very important when you talk about effective enforcement of intellectual property. It is because of this close relationship between tech law and IP law that it becomes important for an IP lawyer to learn tech laws. Intellectual property in general and brand protection in specific, trademark and brand protection in specific, is becoming more and more important with a large amount of businesses that are shifting online and the internet constituting the primary medium of communication and connectivity between people as well as organizations. We sitting here are attending this webinar through the internet. If we are ordering something, if we, whether it is food, whether they are clothes, whether they are books or household appliances, every single thing is available online. And the most successful businesses today in the world are those businesses that have their distribution mechanisms over the internet. Physical Earlier there was a time when FMCG companies with physical brick and mortar stores were the top companies in the world. But today what are the top companies in the world? Google, Apple, Facebook, Amazon, Microsoft. All of these are companies that have their business models over the internet. They are driven by technologies. And as Aditya said when we began this session, these tech giants do need IP protection, and they actually need an okay. Just a second, I have some problem. Yeah, and they do need brand protection and IP protection, and for them there are a large host of issues, and we will be getting into the details of the specific issues, the specific kinds of work that these giants and this intersection between technology law and IP law gives you. We'll be discussing that soon enough as well. Uh, online presence. Online presence, as I mentioned, has become extremely vital for any new and upcoming business. Not having an online presence is in today's world actually seen as a huge anathema to the identity of the business itself. If you're not able to find a website that looks nice, a website that looks legit over the internet, then we are always concerned about whether this particular business is actually a credible business or not, whether the products they are offering, are they having an appropriate level of quality or not. And these are various psychological and subconscious issues that are addressed by having a presence online that is robust and that seems credible and followable. So being visible over the internet, being visible on the cloud, has become quite instrumental for a successful business. And since we are putting out our trademarks, our products, we are advertising ourselves on the business, on the internet as a business, it also becomes even more crucial to ensure brand and IP protection, because as I just discussed, the presence over the internet presents a host of new challenges for businesses to take care of. There is ease of accessibility, there is ease of imitation and distribution. So enforcement itself will be able to be carried on effectively only when a lawyer has a combined and a supplementary knowledge of both tech law as well as IP law.
Indeed. Aniket, what just Aniket has said is like indeed true. It's not only about the fact that you have to be selling your products online, but also advertising your products online. Even if you are not selling your products online, advertisement online is key, is crucial. Without advertisement, people would not really know about your products or your services. So if you're advertising your products or your services online, you need to ensure that nobody is, either, if you're not for example, if you're not even selling the products online, but somebody might make use of that and start selling products online that look like yours. So then you are losing out there. You will have to then ensure that you are protecting your IP online also. You have an eye, you're keeping an eye on what is going online with respect to your products or your services as well. So if you're even advertising your products, you have to see that nobody is infringing or passing off your intellectual property. That is really, really important. And as mentioned by Aniket, OTT platforms are in surge right now. There was a time when there was only Netflix and Amazon Prime, but there are so many OTT platforms right now. In fact, there are so many Indian OTT platforms right now. There has to be certain compliances with respect to the whatever content is being shown over these OTT platforms. One has to ensure that they are compliant with all the regulations implemented by the government, and they have to also ensure that they are not infringing over anybody's copyright or anybody's trademark. So all of that due diligence has to be done with respect to the content being shown on the OTT platforms. And that is done by tech lawyers and IP lawyers themselves. They get to review the content, and then they get to advise the creators that this could be removed, or this should be included, or this should not be included. That is a very, very crucial step that has to be taken. And no content is it can be uploaded online for viewing unless and until that due diligence has been done. In fact, not a very while ago, Aniket and I, we did some this kind of due diligence related work for an OTT platform for a show that was going to come, and it was really fun, and it did involve a lot of technicalities. So that was something that we got to do. So this is something that OTT platforms are because of the uprise of OTT platforms. This is something that definitely is very up and coming. Other than that, there is also patentability of software, which has been in dispute for a long time now. Software per se or computer programs per se are not patentable. There are certain technicalities that have to be proved to be present in your software. Only then one can patent their software itself. It has been the stand that software has to be in combination with the hardware in order for it to be protectable, in order for it to be patentable. That is a very straightforward formula. But then there are certain things that that can be done, certain changes that can be made to your software which would make it patentable. So a patent lawyer would then again have to have a very good knowledge about technology laws and how it functions, in order to ensure that you know that the technology can be patented, the software can be patented. If the software is not patented, then getting that kind of a protection, a very strong protection, would not be possible. So in order to have that kind of protection, technology laws again come into picture.
Absolutely. And the patentability is also a question as far as any new invention is concerned, because we are finding with the growth of machine learning models and artificial intelligence products, we are finding that the existing regimes of patent law and trade secrets law are not enough to offer protection to these new kinds of technologies that are cropping up. And uh, again, there is another layer involved here, which is the creation of protectable material by these machines themselves. Now machines themselves are trained to the extent that they are producing music, they are producing art. However, this new creative output cannot be protected under existing intellectual property regimes because of their backwardness, because of certain restrictions that they have. And all of this would be covered under the aspect of the which lies at the intersection of tech law and IP law. So so far we have discussed what the factors are that have driven technological growth, and what the relationship between tech law and IP law is, and why is it important to learn tech laws if you are an IP lawyer. And now we are going to talk about certain specific practice areas, certain specific tasks that a lawyer is expected to perform in this sphere. What are the opportunities, the specific work opportunities that require you to be conversant with both technology laws as well as IP laws? What are the areas of work in which we can see both of these regimes at play together? And the first such work area that Abhishek is going to talk about is the aspect of international takedown. So, go ahead, Abhishek.
Yeah. So the international takedowns is a mechanism which came into picture after the implementation of the Digital Millennium Copyright Act of the USA, which was in congruence with some of the internet related treaties by WIPO. So this the takedown notice of DMCA basically enables a copyright owner to file a takedown notice to the intermediary, what do we say, content generated platform, user generated content platforms, wherein the platforms which enable anybody users to upload the content on their platform and to monetize upon it. So for example, if YouTube, if you being a copyright owner of a song come across somebody else uploading your song on YouTube and then monetizing upon it, you can file a DMCA notice to YouTube, and you can ask YouTube to remove that content because that infringes your copyright. You have the sole ownership of that content and nobody else can use it. So you have to then ask YouTube to remove that content. Now, YouTube, being the intermediary, would not be liable for infringement per se. It it would not have the liability of of infringement, of infringing your copyrighted content. But what it can do is that it can remove the content that infringes your copyright or that allegedly infringes your copyright. Now, once you file a takedown notice, it is the duty of the intermediary, YouTube or Facebook or Instagram, whatever such platforms, it is their duty to remove that content within the stipulated time. If they do not remove it, now till now they are not liable. But even if you have, even after if you have given the notice, they do not remove it, then their liability begins. They will not be any more protected by the safe harbor provisions. This provision is called the safe harbor provision, basically, which has been laid down under the DMC itself, which protects the intermediaries from incurring any kind of liability until and unless they remove the content. If they do not remove the content, if they do not comply with it, then the content then they shall be liable for it. So this mechanism really helps copyright owners to ensure that their copyright is protected, their work is protected. Otherwise it would be really difficult for them to ensure that that is done, because internet is such a huge wide area. And in order to detect, in order to detect that, you need technology laws. In order to enforce the intermediary liability, in order to enforce, yeah, the intermediary liability, you should know when the safe harbor provisions stop acting in favor of the intermediary. And all of that comes under the ambit of technology laws, even though the protection of even though the enforcement of those rights, or even though stating that I have the rights in this copyright, all of that is intellectual property subject matter. But then as it goes on, it becomes more of a technology law subject matter, in the sense that intermediary liability and stuff like that is more of a technology law domain. So then in DMCA notices, it is more of a subject of technology as well as IP laws. Same is the case with the UDRP complaints, which is the uniform dispute resolution, domain name dispute resolution mechanism, which was implemented by WIPO, which enables anybody to file a complaint to WIPO, a UDRP complaint, stating that this person or somebody is using a domain name which is already registered in their name, or which already they are using. So, for example, if Nike tomorrow comes across a website called Nike.com, they can very well file a UDRP complaint and ask this website to be removed, because the purpose basically of this website would be to to fraudulently gain monetary benefits out of something they don't have the right to. So this becomes more a trademark related subject matter as well as a technological subject matter. So these two are like really important works which intellectual property lawyers have to do, and this does involve technology law related aspects as well. So these are two of like really important works. So Aniket shall be talking about some of the agreements now, which do involve technology as well as IP. So you can go ahead, Aniket. You're on mute,
Yeah.
Aniket.
And guys, you have to remember that you have to actually identify who to issue this international takedown notice to, or who actually to implead as a respondent in your UDRP complaint, because a chain of factors are involved. There is the alleged infringer, there is the internet service provider to that infringer, there is the domain name registrar the person has registered with, there is the actual infringing content, there is the platform, there is the internet service provider of the platform. So there are a large number of parties when you're talking about an online presence. So to actually pinpoint which party is responsible for which action, who to implead where, and who to issue a notice to, it is important to have an understanding, a good understanding of tech laws to reach that conclusion and to complete that in an accurate manner. So moving on, that so these are aspects that are more inclined towards intellectual property that require uh, a prior knowledge of technology laws, and similarly there are various tech law matters that require a prior knowledge of IP laws. And the first of which is essentially software development and licensing. So as we've discussed at length today, a large amount of businesses are increasingly relying on the internet and on other technology related solutions to increase the efficiency and effectiveness of their business operations, of their business models. So and a number of businesses actually use a lot of custom software, a lot of B2B software to give effect to their business functions. For example, if any of you are acquainted, in all law firms, there is a kind of a billing software and a timesheet software that has been custom built for them by a technology company. Similarly, other companies have various softwares to manage their HR and payroll functions through custom built softwares. So in these situations, the technology itself becomes a critical piece of your client's business. And when the technology is a critical piece of a client's business, the protection of that technology also becomes a critical piece of that business. Since this technology and this IP is crucial to ensure that your business continues to function effectively and efficiently, it lies in the interest of the business to actually own the IP over that technology. However, the developer who has built that custom software for you, that developer is also interested in keeping that intellectual property with himself or herself. Why? Because that is a new product that the developer has created. It is the proprietary knowledge of that developer, and the developer would be looking to monetize it on a larger scale, as opposed to simply licensing it to a business who then owns the IP and does not allow the developer to monetize it further. So in this backdrop, it becomes very important for parties in such software development and licensing transactions to actually negotiate and decide who gets to keep the IP, who gets to exercise the rights over that particular technology that the business is relying on. And these are aspects that have to be reflected extremely accurately in the written agreement between the parties. So as you already know, or you might not know, no worries about that, the default position under the Copyright Act, under all of the intellectual property laws in India, the default position is that the creator of the work, the creator of the invention, gets to exercise the rights over that invention or work. That is the default position in the IP regime. So if we are to alter that default position. If we are licensing a software, if a custom software is being built, and after negotiations the developer has agreed to transfer the IP to a business, this movement away from the default position under law has to be specifically mentioned under your contract. A specific assignment clause has to be mentioned, and you have to explicitly state that the position under law is being altered in this manner. To make sure that this happens accurately, it is again important to learn tech basics. You have in your assignment clause, you will have to specify the actual components of the technology over which you have rights. You have to understand what source code is, what object code is, what a developing environment is, what a design element is, because all of these are aspects that your client as a business would be interested in protecting. And it is important to ensure that you have appropriate safeguards to protect this technology from your competitors, because if this technology goes to your competitors, you will lose your business edge, you will lose that competitive advantage that you earlier had. So it is also important to put in non-competes over the sharing of this IP on the developer itself. Even if the developer has transferred this particular piece of technology and IP to you, you will have to ensure that the developer does not take up a similar assignment or a similar work product for a different client that might be your competitor. So this is one of the aspects, a transaction where software development and licensing is to be carried out. And the aspect that I just spoke of is the aspect where the parties have agreed to transfer the IP to the business. However, what if that does not happen? What is the situation that will come up in that regard? To identify that also, you need an understanding of technology law. There is something, an arrangement known as a software escrow arrangement. Now, you probably would already know what an escrow is, but in the financial sense. However, where the business and the developer are unable to reconcile their differences with respect to the storage and transfer of proprietary knowledge in the software, in the application, whatever piece of technology it is, a software escrow arrangement is what is entered into. Excuse me. So it is important for a business to have access to this proprietary knowledge, because the technology is critical to the business, as we mentioned. So in case the developer is unable to provide maintenance for that software, if the developer is unable to provide improvements in the software, it becomes important for the business to be able to do that itself. It needs to be able to support and maintain its software without the help of the developer. That is why the business will need access to the fundamental blocks of the software and its application. However, the developer will not be interested in transferring those fundamental blocks because it is their proprietary knowledge. They have spent their time and effort to build it. They, by default, should have the right to monetize it. So, in this situation, to reconcile these differences, proprietary materials are stored with a neutral escrow agent that releases them to the business only in case of certain triggering conditions, only in case of the developers, say, for example, insolvency or dissolution or an inability to perform support and maintenance. For example, during this pandemic, a lot of engineers were not able to travel to their offices and provide the maintenance services that were required from them. And an escrow arrangement would have been greatly beneficial in that regard. So when you're drafting, when you're negotiating and drafting for an escrow transaction, it becomes extremely important to identify and list out the specific technical materials that have to be deposited inside the escrow account, whether you'll deposit the source code, the object code, the product keys. What actually are you going to deposit? Because even if you miss a single thing that was supposed to be deposited, you will not be able to carry out your business properly. So, and knowledge of tech law also becomes important here, because you will have to reconcile the developer's interest in protecting its IP and the business's interest in ensuring the survival of its business functions.
Indeed. So, other than what Aniket said and what I spoke about earlier with respect to DMCA and UDRP, there is a general infringement of copyright and trademarks as well that takes place online, such as piracy. Online piracy is so rampant these days. There are numerous websites such as Pirate Bay or websites providing online content such as F movies or one movies, which are basically being run on piracy. So what has to be done is that one has to just a second. What has to be done basically is uh, you know it is pertinent to know how to combat these such issues. So online infringement, if somebody is so for example, Great Grand Masti, the movie is an example where which was which incurred great losses because it was already made available online by someone. So then in such a cases, a John Doe order could be requested. A John Doe application could be filed, wherein you do not know who is the infringer, but you know that this is the place where the infringement is being committed. So you will ask the court, you will request the court to suspend that website or to just disallow the functioning of that website for the time being, so that the losses could be made, what do we say, contained. So in such cases also technology law is required, in the sense that you need to first map where is it that the infringement is being committed. You need to identify the websites, the places where the infringement might be committed. So that way, technology comes in handy, so that you can go and state to the court that okay, this is where this such an infringement is being committed. Similarly, with respect to trademarks, also e-commerce, there have been like a surge in cases wherein the surge of cases wherein the plaintiff is aggrieved by counterfeit products being sold on these e-commerce websites. So that is also something wherein technology has kind of become the enabler of the infringement. So then the solutions to it would also lie in technology laws itself. There is huge passing of content, of material, of trademarked of somebody else's trademark, of somebody else's products, of somebody else's trade dress. It is really difficult to gauge the quality of a product if you are if you cannot see the product. You can just, if you cannot just really feel it, if you cannot make sure if that is actually the original product or not. So in this way, a knowledge of technology law and how should you go about such things, if technology law can provide you better remedies than just an infringement or a passing of action, you need to know that. So that with respect to that also, a knowledge of technology laws can definitely come in handy.
There are other technology law transactions also, and I believe Raki, this will answer your question. So, what are the areas, what are the contracts where tech and IP intersect? First, if of course I've already discussed, is your software development and licensing contracts. The second would be your software escrow arrangements, and the next thing, the next transactional contract that where both knowledge of tech law and IP law is important is your application integration. Now this is something that you see all the time. uh, Whenever you go to a new website or a new application, you get that option to log in using Facebook, right? And whenever you order food through Zomato, or if you order a cab through Uber or Oyo, so you find that the application enables you to track your order or cab through a map. So now that is a Google map. How is a Google map visible inside an application for a Uber or a Swiggy? All of this is made possible through API integrations. Now, when we're talking about API integrations, we're essentially talking about the mixing up of two different businesses, of two different intellectual properties inside a single application or software. So when these these kind of arrangements are being finalized, it becomes extremely crucial to include specific clauses related to the intellectual property and proprietary rights of each party, right? And in the intellectual property clause, along with the confidentiality clause, is actually the most important and the most negotiated clause when we're talking about integration agreements. And in a number of contracts, a simple statement that is adduced states that no intellectual property shall be exchanged, copied, or owned by the parties. However, it is always suggested to have a detailed IP clause, and a detailed IP clause will ensure reduction in any potential and future disputes, and assurance as to the protection of your IP vis-a-vis the IP of that is owned and exercised by the other party. So when you're drafting an integration agreement, you should have a separate section for your branding guidelines. You should have a separate section for specified uses of logos and other branding materials. You should have restrictions on advertising and on marketing uses. So all of these things will come up only if you have a robust understanding of the interrelation between IP law and tech law. Now, one of the most lucrative areas where IP and tech intersect is work related to technology transfers. Now, technology transfers have turned into a huge chunk of work that is actually performed by TMT teams in law firms. A lot of tech transfers are taking place, and tech transfers involve a whole gamut of IP laws. They involve patents, they involve trade secrets, they involve designs, they involve business methods, they involve technical know-how. All of these things are protected under different IP laws. It is extremely lucrative because these transactions themselves have a significant amount of interest and monetary worth associated with them. And these technologies that are the subject of tech transfers, whether international or intra corporate group, all of these are built after a significant amount of investment. However, with the ease of technology, things like 3D printers and online accessibility, these technologies can be imitated with relative ease. And that would not do justice to the significant amount of investment that has gone into it. So, in these transactions, it becomes as a subject of negotiation as well. It becomes extremely important to identify what the existing intellectual property is, that is the IP, what is the IP that is being transferred, and it also becomes important to identify what kind of intellectual property might be created during and as a consequence of the tech transfer. Say I am transferring certain technology to you. Say I run an electric metering business, and I like right now, the municipal corporations, they come to your home to collect a reading from the meter. I want to build a remote meter, and for that I am entering into a tech transfer agreement with, say, a Japanese company. So it will be in the interest of that Japanese company to protect its own IP that it is transferring to me, and it is a subject of negotiation for us to discuss who will own the IP that will arise out of a transaction where the Japanese company and I are building some product together on the basis of the IP supplied by that company. Right. So we have to identify the existing IP and what kind of IP may be coming in as a result of the tech transfer. And accordingly, we have to incorporate specific conditions dealing with both these situations inside the contract. And again, how the any improved technology, or how any jointly developed technology will be protected, who will exercise the rights in those regards, that is one of the most negotiated aspects of a tech transfer agreement. Now, typically, the existing IP remains with the transferor, the entity who is transferring, and they only accord certain end use restrictions on the transferee, the person who's getting the technology, while the rights in improvements or jointly developed technologies are highly negotiated. So parties may either choose to grant each other the license to use it, And while restricting other rights such as sub-licensing, assignability, they might include some territorial restrictions. But the important thing that remains is that all of these have to be defined clearly, and you will be able to perform this work only if you have a robust understanding of that particular piece of technology which is being transferred and what its potential applications can be. And for that, you need to be aware of both the regime as far as IP law is concerned and the regime as far as your tech law is concerned. Okay, so there are a few questions. I'll just take these questions quickly. Divya asks, is there a need to learn data protection laws if you are an IP lawyer? How is it useful? Okay, so Divya, data is protected under copyright law. Data and data sets are protected under copyright law. So they definitely do have a common point. So if you are to implement data protection laws effectively within your organization, then it would be beneficial to have a knowledge about IP law as well. So actually, I would like to turn your question. It is not important to need data protection laws if you are an IP lawyer, but it is important to learn IP laws if you are a data protection lawyer. Raki asks, what are the technology and IP related contracts or documentation an e-commerce entity in health sector needs to? Okay, that is extremely specific, and we'll have to do like an entirely separate session for that. So some of them, of course, are the common ones: your privacy policies, your brand guidelines, and your website terms and conditions. Rajiv Niwaskar, how is it safeguarded from the constitution as a prohibition to business? I'm sorry, I don't understand this question. Could you please reiterate it over here in the chat? Then I will be able to take it. Any other question? WhatsApp and Signal are developed by the same person. How it was ensured? Again, not able to understand the question completely. Lucky, you can get in touch on LinkedIn, or you can go to our website and you can leave your details there, and one of our counselors will call you and guide you. Okay. So the last thing that we're discussing today is with respect to regulatory compliance and due diligence. There are a number of areas where technologies have been widely adopted only recently. The rules and regulations in these areas are still catching up, and these technologies are still operating in an area that is not clearly defined, in a regulatory gray area. So the prime example being online gaming. So games like fantasy sports, like Dream 11, like your mobile Premier League, Paytm Tambola. There are a number of things. There is no regulatory regime over this. Then you have your fintechs. So a number of fintechs, payments related fintech businesses are regulated properly. However, other fintechs such as those related to crypto or alternative lending such as Faircent, Lending Cart, these are not regulated properly. OTT platforms, which were recently, up till now, they were self-regulated. They were under a self-regulatory framework, but they have been very recently brought under the framework of the Ministry of Information and Broadcasting. So these are just a few examples of the areas that are still in their nascent stages. Regulations in these areas have not been developed completely. So there is a lot of scope here for lawyers to engage with regulators, with sectoral authorities, to ensure the establishment of a sustainable framework. The sustainability has to be ensured with respect to both the ease of doing business as well as the ease of enforcement of rights and contracts. And both all three of these things have to be ensured, have to be kept in mind while creating a regulatory framework around these new and still in development technologies. So even in-house councils, there's a huge scope for in-house councils here, as they can lobby the government to get some favorable policies. And a number of think tanks are doing this work, like Vidhi, like Bridge Media Consultation, and all major law firms have policy and regulatory teams. So having an understanding that crosses the domains of both tech law as well as IP law will enable you for a role that is regulatory in nature and will enable you to perform work that is government facing. So that is the final aspect that we would like to discuss today, where tech law and IP law intersect. So all of the kinds of work that we discussed today, uh, everything that we discussed today does, you can find all of it in the public domain. It is not some kind of knowledge that is ethereal in nature, and all of it is available in public domain, and you can find it if you have the time and space to conduct the kind of research that we have conducted over the past years. So however, if you want to learn all of these matters in a way that is structured, in a way that is guided, then I am pasting a link here, and you can have a look at this. You can have a look at the syllabus, the kinds, and the huge breadth of matters that are taken up and taught. And all of the matters that I mentioned today are taught in the course that I have shared this link. You can check out the syllabus, and if you need any sort of career counseling to be done, then you can on the website leave your details, and one of your our counselors will call you and guide you. So that is it, guys. Do you have any questions for me or for Abhishek? Do you have any questions for us? Okay, Mr. Rajiv, non-compete clauses are not allowed in perpetuity, and so you have to restrict the temporal limits. You have to restrict the time for which the non-compete will be applicable. You cannot leave it open-ended. And we don't need to go to the constitution for that. Section 27 of the Indian Contract Act also restricts an open-ended non-compete clause. Okay, Amit has a question. I'll just unmute you. Go on. Amit, you can ask your question.
Hello, am
Hi.
I audible?
Yeah, yeah.
So my basic question was regarding to the GDPR. So it is a hot
Mhm.
topic. So what is the future perspective regarding the same?
Okay, so we've done a bunch of webinars on GDPR. I actually did one yesterday. You can go to YouTube and check it out. And this was not the topic for today, my friend.
No, but I agree to that because it is related to IP and IT law. So that's why I was thinking of doing something in GDPR. So it is going to be benefiting me in IP law as well.
GDPR in IP law, there's not a huge relation, as I just clarified for Divya as well.
Mhm.
If you are a data protection lawyer, it is in your interest to learn IP law and not the other way around.
Okay, okay.
Of course,
Thank
but
you.
if you want to diversify your practice area, then definitely that is useful.
So
And
it is going to be benefiting me in any case, right?
yes, absolutely. Because uh, see, actually, you should look at the webinar that I took yesterday on this topic, because I'm talking in that webinar. I talk about the opportunities for GDPR related work, but just in brief, it is important because data protection work is really up and coming, and all of the people that I've spoken to in the past year, all of them point towards the fact that the coming decades, at least the coming 2 decades, are going to revolve around data protection law. Even research firms in India that rank law firms and legal chambers, they have recognized data protection as a separate vertical for the first time this year. So we can definitely see that there's going to be an uptick and upsurge in work in the data protection domain.
Oh, thank you so much. Thank you so much for your input.
Anytime, anytime. If you need any kind of career counseling done, you can leave your details on our website, and our counselors will call you. Same goes for everyone else. And Amit, you should check out the webinar that I did yesterday. It is available on YouTube.
Sure, sure. I'll do the same.
Yeah. Okay, thank you guys. We'll end this session now. Thank you so much, Abhishek. Thank you guys for attending.
Thank you for joining in, everyone.